Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who've ever filled out a Form 4473 and you get down to Section 21K, you will know that it asks, have you ever renounced your citizenship? Now, I've always thought that was an odd question. I always thought to myself, well, who the hell would do that? Well, today I'm going to introduce you to a gentleman born in Missouri, living in Wyoming, who got cute and decided that that's exactly what he was going to do, renounce his citizenship. He now wants to possess firearms for purposes of hunting, and the United States government has said, no, you can't do that. Brought suit in a court in Wyoming, and the court has spoken. So today, let's spend a few minutes and let's talk about the man who renounced his citizenship and lost his gun rights. Okay, America, this is a bit of a bizarre case. Didn't think we'd ever come across something like this, and that's one of the reasons we decided to do a video on it. I'm going to introduce you to a gentleman. His name is John Durrance III. He was born in Missouri. He lived on a huge ranch not far from Devil's Tower in Wyoming for many, many years. His family owned the ranch since the early 1970s. He raised his family there. He still has children that reside in the state of Texas. However, for whatever reason, in 1993, Mr. Durrance, and again, I don't know the reasons why, although he has accumulated a considerable amount of wealth, renounced his United States citizenship, became a citizen of Ireland, but resides in the Bahamas. Now, he does travel to the United States because his whole family still lives here, but when he enters the country, he comes in here on B1 or B2 non-immigrant visas. In addition to that, Mr. Durrance has hunting licenses both in Wyoming and Texas, but the problem is he can't hunt, at least using a firearm, because there is federal law that says if you renounce your citizenship, you are not eligible to possess a firearm. This is a constitutional challenge to those laws. The case is Durrance III v. Bondi. It was filed in the United States District Court for the District of Wyoming. It is no longer filed there because the court has thrown this lawsuit out. Federal Rule of Civil Procedure 12b-6 says that, hey, if the plaintiff can't even allege a cause of action in their complaint and their pleadings, we're just going to go ahead and dismiss the suit. And that is exactly what the court has done here. Now, this is a constitutional challenge to 18 United States Code Section 922G5, 922G7, and 922Y sub 2A. These statutes comprise the prohibition of firearms against aliens, those who have renounced their citizenship, and provides an exception for some people here on non-immigrant visas to possess firearms for very limited purposes. Since this is a constitutional challenge, the court had to go through the Bruin inquiry, which is number one, does the text of the Second Amendment cover the activity? They believe it does. So number two, then, the government must justify the existence of this law through historical analogs. The problem for Mr. Durrance is the government has done exactly that. This is how the court has seen it. The government asserts that Section 922G7 is analogous to the country's historical tradition of disarming those who have not sworn an oath of allegiance to the United States. This court agrees. The United States, during its founding, prohibited those unwilling to swear an oath of allegiance to the United States from possessing firearms. And this court believes those founding-era laws are representative analogs to Section 922G7's firearm ban for those who have renounced their citizenship to the United States. Now, Mr. Durrance tried to frame the issue differently. He said, is there a historical analog that bans possession of firearms by those who are not United States citizens under any circumstance whatsoever? A very broad way of looking at it. Don't know what the answer is, but it could be yes to that too. The court very wisely pointed out, no. The issue here is much more narrow. It's about what you did with your citizenship. The court has ruled, yet plaintiff contends there is no historical evidence from the founding era that non-citizens lawfully present in this country were categorically disarmed as Section 922G7. However, plaintiff improperly frames the ban in Section 922G7. Section 922G7 does not ban firearms from non-citizens lawfully present in this country. It more specifically restricts firearms access for those who, having been a citizen of the United States, has renounced his citizenship. And that is a big deal to the court. And candidly, as I was doing a little soul searching on it, it was a big deal to me. And here's why. Because I think the court has really articulated it well. To renounce your citizenship and become a citizen of a foreign country, as plaintiff did, includes not only a declaration of allegiance to a country other than the United States, but also a repudiation of the allegiance to the United States. But then Durrance had another argument, which is, listen, there are exceptions in 18 United States Code Section 922 that says if you're here on a non-immigrant visa, like a B1, which he was, and you are licensed to hunt, which he is, and you are using the firearms only for hunting or sporting purposes, you may possess them. And that is true. The law does absolutely permit that. But that's if the only barrier to possessing firearms is the fact that you're here on a non-immigrant visa. But for Mr. Durrance, there's a much bigger problem, isn't there? And the court put it this way. The exception at issue provides that subsection G5B does not apply to any alien who's been lawfully admitted to the United States under a non-immigrant visa if that alien is admitted to the United States for lawful hunting or sporting purposes or is in possession of a hunting license or permit lawfully issued in the United States. Section 922Y2A would apply to plaintiff as an alien admitted under a non-immigrant visa for lawful hunting purposes if it weren't for Section 922G7. Section 922G7 prohibits firearm from those who renounce their United States citizenship, and the statutory exception in 922Y2A does not apply to those renouncers. So, Mr. Durrance, you were correct there. There is a very clear exception in those statutory prohibitions. And again, if your immigration status was the only reason by which you could not possess a firearm, the court here even acknowledged that you had a plausible argument. But no, for whatever reason, you decided to renounce your citizenship. And therefore, in the eyes of the law, you have voluntarily and willfully placed yourself in a position where you are no longer part of the people. Listen, we'll go ahead and keep our eyes on this case to see if it's appealed, but I do believe that the United States Department of Justice has a pretty solid argument on this particular issue. Okay, the case once again is Durrance v. Bondi. We'll link up the order of the court down below so you can geek out on it for yourself, and that way you don't have to take our word for it. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.